Hello and good afternoon, everyone tuning in. It is time for your weekly legal show, Speaking Legally, where the legal meets the cultural. I'm Dr. Stacey N.C. Grant, joined by our two co-hosts, Royce Russell Esquire, Edward Pichardo Esquire. Welcome to Black History Month. Welcome to season 2 of Speaking Legally. We're so glad that you've been tuning in, you've been joining, you've been sharing out the broadcast. You know, we're always ahead of the curve before it hits mainstream media. We've already talked about it on the show. So thank you for being here. Hey, Richard. Yep, here we go. So I'm going to let my co-host say hello, and then I'm going to talk a little bit about what we're talking about today. So over to you, Mr. Russell.
Welcome, everybody. Thank you for joining us. I know that the information we give today, as we always do, will be very informative, and you need to put, as Dr. Grant said, put a pin in it, put it in your back pocket, hold it, because it will become relevant to most of you out here, because we're living in a new day and a new era, and issues to be litigated are at the forefront, especially when we talk about what we're going to talk about today. So welcome. Easy.
Thank you, Mr. Russell. Señor Pichardo.
Hello. Hello, everyone. Good afternoon. Buenas tardes. Buenos dias. Welcome to today's show. As always, you're going to find the information quite fulfilling and educational. The topic definitely has to be UNITY, unity. Whatever you learn on this show, please share with friends, neighbors, and relatives. And, you know, if you can only touch upon it but not expound upon it, that's why the lawyers are here. You know, you got the number, have them call, and we'll fill in the rest. So welcome.
Thank you both. And yes, we're going to kick off the show acknowledging the fact that it is Black History Month. I mean, we all feel that Black history is every day. But while it's being acknowledged throughout the country, we definitely want to make sure that we're capitalizing on raising our voices during this month to let people know that, you know, we are more than just the horrific transatlantic slave trade, and we survived in spite of all that we went through coming to this country from all parts of the diaspora to be able to still be the leaders, the movers, and the shakers. And we've shown that we're the ones that not only built this country on the hands or by the hands of the slaves, but now we're also the ones running the country. So happy Black History Month as we remember our legendary queen, Cicely Tyson, and legendary Hank Aaron. There's so many that have recently transitioned, but we just want to highlight and say happy Black History Month to everyone who understands the importance of knowing who you are and from whence you've come. It was before the Mayflower.
Can I add a little to know here? To know, and maybe our viewers or listeners, or however you see the show, maybe you can call me at 718-785-8890 if I have this fact wrong, and let me know whether or not there exists a Cicely Tyson school in the greater New York area, Harlem, from where she was born and raised, because I do know that there is a Cicely Tyson High School out in East Orange in New Jersey, which is thriving and doing well. And so what came to my mind is, how can New Jersey have a school named after this queen and not Harlem, where she was born and raised and where she came from, not have a name? So please advise, as we say in the legal world, please advise. Thank you.
I would welcome you to chat as well on this. I believe that Dr. Grant accepts the chats they pop up on the screen and let us know. I mean, that's an extremely interesting question. I mean, Cicely Tyson was a queen. I recently saw a PBS show talking about the history of Black female celebrities, actresses, entertainers, and it ranged from Cicely Tyson to Halle Berry to just a number of Black female icons. And one of the things that struck me about Cicely Tyson was, you know, before it was fashionable for these Black actresses to select their roles carefully and make sure that they were roles that were going to portray positive role models to the Black community and strong role models, she was doing it. I mean, when I was growing up, I watched Sounder. I watched the story of Miss Jane Pittman, and, you know, it just was, she was amazing to watch. And I would welcome, you know, folks who haven't seen those films to watch them again, to watch them. And even if you have watched them, you should try to make sure you watch them with your children if they haven't. I think it's important that we, impart these jewels to the younger generations. I mean, I have a daughter, 15 years old, and that show that I was talking about, I immediately, as soon as I was watching it, I sent her the title, like, hey, check this out. If you can't do it now, go on the PBS website and pull it up. This is something that you need to watch so that you understand the journey of Black women, especially in the entertainment industry. So kudos to Cicely, and with Hank Aaron. I mean, oh my gosh, man, that brother, he was, just amazing,
One of the things I would like to add to what you're saying, Ed, when we look at Cicely Tyson, and then we'll move on to the show shortly, is that, and Dr. Grant, I always keep my hand on this, right? How society and how Black women are viewed and in their natural form, right? You see this whole new movement of taking pictures without makeup, taking pictures without the Photoshop, taking pictures in what we call COVID gear, not always dressed up and in your sweatpants and your sweatsuit. And so when you look at acting, you always see and you always envision not the real me. But when it came out of Cicely Tyson, she was the real her. There was nothing fake and phony about her look. Her look was her look. That's it. And the role she played those roles and dominated the role rather than the look of the role dominating her. And so when we see all this coming back to natural and coming back to, no makeup and who's wearing what and how so-and-so has sneakers on and so-and-so doesn't, and this, be you and do you. Everything else will come to the top. She did her and everything rose to the top. And she did it in such a way that you didn't think about anything else. Same thing with Hank Aaron. He did it in such a way that you didn't think about anyone else. He's a home run king, no matter what anybody said. He is the one. No steroids, no nothing. He did it purely off the skin off his back. And so, I welcome that, and I look forward to us getting back to that. Just being who we are at the barest and the most natural moment, and presenting who we are to everyone, and let the truth be told.
So to your point, I was blessed to have had multiple times to be in, I call her Queen Mother Cicely Tyson's presence, and her stature, her class. It's almost palpable. Like when you're around her, you're in awe. And I remember the second time we connected, it was backstage at WBLS Circle of Sisters, and she was there for one of the panels. And of course, as soon as she's in the building, everybody wants to come and clamor who had access to backstage. And one of the team members wanted to take a photo with her, and they actually pulled up their cell phone camera, and she was like, oh, no, I don't do cell phone pictures. We'll let the professional photographers take the shot. And I said, yes, mother, you better set them straight. Her standards were her standards. So not only did she not take certain roles because of what the roles represented, she also just had a standard of who she was and how she was represented. Because something as simple as a photo could distort her character and her class. And I will never forget that moment. I was laughing so hard, and I was grateful that I was in a professional shot with her. But it was just another example of, for Black women, we didn't have a lot that we could see in the media and on the screen. And she took that seriously. And she wanted to make sure that everything she represented honored who she was as a Black woman. So happy Black History Month again. We can go on and on because we're all fans of all of our ancestors who have gone before. They did more with less. They endured so much so that we can have an opportunity to do it speaking legally. So thank you to our ancestors.
I just want to say one more thing. I examine the younger folks I invite the younger folks to examine the longevity of Hank Aaron's career. Slow but steady. That home run, the amount of home runs he hit in a career was a steady process of him hitting those home runs season after seasons. Because sometimes our young people get enamored with the idea of quick and easy success, instant success, without understanding that sustained success is really what rules the day, especially for many of us who grow up without these huge resources at the beginning, and we have to slowly accumulate these things and move forward and steadily do what we got to do. And so, that's, I examine, I invite an examination of that career because it speaks to that.
Absolutely. Slow and steady wins the race. So that is a great point. And I think with this microwave society that everybody wants to press a button and everything happens, that we need to appreciate. And even with Cicely Tyson, her career didn't really kick off until later in her life by the standards of what actresses and actors are usually used to casting early and doing. So they're both examples. Stay true, as Mr. Russell said earlier, to who you are, do your work, and watch it work for you. So with that, it's a great segue into talking about work. We're in the middle of this new global pandemic reality, right? COVID-19 has not disappeared. We know that now the vaccines are available. There are things that are opening up and moving. This new administration is taking a very aggressive approach on how they're going to make sure that these vaccinations are available more globally throughout the country. But then there's some other issues. Parents have been dealing with being at home, monitoring homeschooling and working from home. And as things open up, that might shift and change their capacity and their ability to be able to continue that if their places of business open back up and no longer require them to work from home. So it's an interesting dynamic that we're going to see playing out, that our attorneys have actually started investigating and researching, because in our community, some of us don't have luxuries that others have, that they can continue to work from home in spite of different cities opening up. And here in New York City, what industries that were closed that are now opening and require workers to come back? What do you do with your kids if they're still on remote learning? What do you do when they do go back to school and someone gets a positive case? The law is now that everybody has to be quarantined. So that child still has to come home, even if they were going into the building. And the quarantine is not 2 days. That's an extended amount of time. How do people navigate this new normal? How do our people in our community prepare and arm themselves for situations where their employment might be in jeopardy? So I'm going to turn it over to our legal experts to help us navigate where the legal meets the cultural.
Well, what I can say to the subject matter and to the various points that you laid out is that, first, employment law is a very big section of the law. I mean, it covers anything from severance agreements to separation agreements to wrongful termination. So we're just going to take a little bite out of the apple of employment law to kind of give you some of the foundation that you need in order to protect yourself. And so one of the things you need to know is, what are the laws in your state, right? Are you a right to work state? Are you an employee at will state? In New York and most of the states, you're an employee at will. And so what does that mean, an employee at will? That means that the employer can fire you with or without cause. So let's define what with or without cause means. So with cause means you stole, you came in late, you did something that the employer is labeling and saying, this is the reason why I'm terminating you. Without cause means that you can come in Monday morning and they just say, you know what, Dr. Grant, it's been nice knowing you. Give you no reason. Don't have to lay down any foundation. It's just that it's time to move on. And so where we see most of the litigation when it comes down to employment law is really in two scenarios. One scenario where the employer gives a reason, but the reason is not really a true reason. The reason is what we call propaganda. There is illegal motives behind it. The illegal motive might be discrimination of some sort, whether it's race, ethnicity, sexual origin, religion, but they give the excuse that you came in late over a period of time. And so one might want to bring a lawsuit to show that that is a false reason and pull the time cards, get the metadata. I'm trying to keep it very simplistic so we can understand the foundation of it. Might do those things. Then you have a situation where the employer says nothing. And a smart employer will do that because then you have no grounds to really come at them to say that the termination was wrongful. Only thing you could do is assume, and we know what happens with assumptions. And the law is very clear when it comes down to employers. Only thing employers have to do is show a business context for why you were released. And one of the contexts can be, we no longer have a need for her. We no longer have a need for him. That's it. This way, there is no, but what's behind door number one? It's very hard to prove what's behind door number one. And the reason why we're talking about this in a broad sense is because we will talk about it in the world of COVID. But before you can do that, you need to talk about it in the broad sense.
If I may add, one of the examinations we do in terms of that at-will context also is whether or not there is an employment contract between you and this employer to make that determination of whether you're at will. And when I say contract, I'm actually talking about there are some workplaces where, the employer will say, listen, we're going to do this contract. We agree to barring any, misconduct, you work here under these circumstances for this length of time with the ability to renew. That's something, that at that point it removes it kind of out of that immediate at-will context. It also provides us with a map as to whether or not there is a certain due process procedure that's been agreed to by the employer that will be observed prior to any sort of termination or layoff. Also, contract may mean something bigger, like if you are at a workplace that has a union, the contract in that case is the contract between the union and that employer or vis-a-vis your boss. So, we kind of look at that when we first have somebody come in and determine whether or not they're an at-will employee. I just wanted to drop that little bit there since you were.
Well, I think it's important because when you talk about one of the exceptions to the at-will type of theory, legal theory, is to look at whether or not the employer breached the implied contract, right? Because if there is a physical contract, then that takes you out of the employer-employee relationship and may put you into the relationship where you are work for hire, and therefore you need to receive a 1099 at the end of the year, which is a tax document. There is a physical contract that you sign. And so I just want to make sure that we are talking about and that folks are consistent with, if you're not signing any contract and you're getting a check every 2 weeks and there's no ifs, ands, and buts about it, you're an employee and there is an employer, the only contract that really exists is what we call an implied contract of good faith. That you do your work, and we pay you to do your work.
And let me just touch on one little thing too, okay? Because sometimes even if you're working at will, it's important to examine the reason why you may have been terminated or laid off, okay? Because that has implications with respect to you collecting unemployment benefits if you've been working there a certain amount of time in order to become eligible for unemployment benefits. Because sometimes people will think no matter what, automatically I'm supposed to get my unemployment. But if you engaged in misconduct, what happens is the employer may decide to object to your receipt of unemployment because they're going to argue is that you fired yourself. Like, remember, you're not entitled to unemployment if you say resigned and left the job of your own free will. And what falls within that context is if you engaged in misconduct and the employee can say, well, by virtue of that misconduct, you fired yourself and therefore you're not eligible for unemployment. And we can talk about on another show maybe what you're supposed to do about that in order to fight that, because there's a way to fight that as well. Because I've had people say, hey, now they're trying to, not give me my unemployment. And I talk to them, well, why? Well, this. And I say, okay, this is what you do. So we can talk about that. But I just wanted to drop that little jewel.
Well, I think it's important that you drop it where you see appropriate, because in doing so, it resets the table and talking about, hey, no, it resets the table really, and talking about what are the grounds to be terminated, right? And so one of the things we talk about is illegal activity, right? You stealing, you taking what we call trade secrets and divulging it. You are what we call stealing time. You're punching in, saying you're at work, but meanwhile you're at McDonald's or you're at a loved one's place, right? You could be harassing someone. You could be committing insubordination, not listening to your higher up, your leader, your team leader, your employer. You could have unexcused absences or excessive absences. When you have those type of things that are the reason for your termination, and we should do a show, and we will do a show as to unemployment benefits, you can almost guarantee yourself that you will not collect unemployment because there is a reason why you were terminated, grounded on fact. So why should an employer, when we say unemployment, we have to understand that the employer pays a portion of the unemployment with the city and state. So therefore, why would an employer want to pay a portion of your unemployment when you have stolen, done some illegal act, harassed someone, had unexcused absences, had excessive absences, was insubordinate in some shape, form, or fashion. And so you can see why that doesn't happen. But one of the reasons that you find yourself in court, or one of the reasons why clients often call me and call you, Ed, when they consult about employment, is discrimination. And I want us to we're just going to glance over this, and we'll probably do a longer show on this, but I just want to say discrimination is very, very hard to prove. One, it is just not what happened to you today because of the color of your skin or because of your religion or sexual orientation. It has to be a pattern in practice for which you can show apples against apples. And what do I mean by that? You have a person of color who's 6 feet tall. You have to find someone who's not of color, who's white, who's 6 feet tall. That may sound like an exaggeration, but the law is very clear in ensuring that businesses can do what they need to do and conduct their business without being filled with litigation in reference to discrimination. So it really comes down to an apples to apples show. And if you can't show your lawyer apples for apples, then it is highly unlikely that they're going to take the case. And you also have to understand, people have this myth that because they want to sue their employer for wrongful termination based upon discrimination, that means the attorney will take the case for free. That does not mean that.
You will for free?
No, you're not. No. You, and especially in the context of employment law, you would definitely be paying an hourly rate because a jury could come back and find that you were discriminated against. However, if you've only been there for 6 months or 5 months, what's the value of the case? If you've only been there 2 years, what's the value of the case? And on top of that, every employee, whether at will or otherwise, has to and is obligated to mitigate their circumstances. And so, as Dr. Grant would say, put a pin in it and define that. So let me define it. That means if you're working at a job for $5 an hour and you feel that you were wrongfully terminated, and guess what? You are correct. And you were wrongfully terminated because your color of your skin, discrimination. And you brought that lawsuit 3 months after you were terminated. Well, the court will look at as part of your award, if you are granted an award or settlement. Well, what did you do in those 3 months that you were terminated? Did you look for a job? A duty to mitigate. Did you find a job? Yes. If so, if that job was paying you $4 an hour instead of $5, then you only get the difference. Ha.
So you can't just be fired for a discriminatory reason and sit and wait for the settlement. That's what you're saying?
That's right. The law doesn't. Repeat that one more time, because you said it subtly, and I know you didn't mean it to be subtle. Say that one more time.
Well, you can't just be terminated for a discriminatory reason and sit around and wait for the settlement.
Exactly. And that speaks volumes, because a lot of people believe that because they have this lawsuit, the lawsuit is going to pay them all back pay. They're going to walk away with all this money and they don't have to do anything. But not so fast, grasshopper. The judge and the court will look at What have you done? Have you put out applications? Did you fulfill your duty to mitigate? And if you did, what is the difference between that pay and the pay that you receive? The reason why I bring this up is that attorneys take that in consideration before taking on a case. And that's why you will have to pay hourly, because the disparity between what you made and what you're making now might be so little that it's not worth the energy or the return on the investment for an attorney to take on that challenge.
Well, one of the other things I also see is when these incidents occur, one of the first things you want to do is you want to go either to file a complaint with the EEOC or the Human Rights Commission.
I would say it's mandatory.
It's mandatory, and you have to have that investigation done. And the hope is at the conclusion of that investigation that you'll get what's called a right to sue letter. Now, that right to sue letter is important as well, because what happens is that if the allegation, the claim is substantiated, that gives the attorney a pretty good idea of your chances of success. The problem is sometimes you'll get a letter back saying you have a right to sue, but without a substantiation of the allegation.
It's called a punt letter, what we call the punt letter. P-U-N-T, punt letter. Let's call it what it is. It's called a punt letter.
And usually those clients don't want to actually provide you with the letter. They saying that they can't find it, that it's lost, and you have to really know, I really need to see that letter. And once you see it and you see that, unfortunately, you have to inform them that, listen, if I do take the case, you'll have to pay me hourly, because I'm not sure whether or not we really will be successful. And this happens a lot of times too, when you have individuals who are representing themselves pro se, and at a certain point in the litigation, they're trying to find an attorney that will take the case, because it becomes pretty burdensome on somebody who isn't legally trained to be able to carry on that litigation. So just something to think about.
Well, I mean, look, you have an obligation within 180 days. For those who don't know, you have an obligation within 180 days to file a claim with the EEOC if you are claiming any discriminatory practices. And for those who don't know, as a former EEOC mediator, there's 3 avenues that they can take, and Ed, you expounded on one of them. One avenue is that they can tell you just don't have a claim. And sometimes they just need to do that. And sometimes the EEOC needs to draw the line and say, I don't see a claim here. The other is a right to sue letter. And that gives you A and B. The A is right to sue because we substantiate what you're saying, which leads you into the third option, that they take on the case themselves, or the punt letter, which is a right to sue. They're not saying that we don't believe in your claim, and they're not taking your claim. They're saying you have a right to sue, and you can find a lawyer that will take your claim. And the reason why all of this is important is, as you said, Ed, it substantiates and it forecasts what a judge will think about your case and the other side. As soon as you walk in the courtroom, the judge will say, well, have you filed a claim with the Human Rights Commission, the EEOC, Equal Employment Opportunity Commission, or have you filed with the Division of Human Rights? One or the other. They will ask, have you done that? And if you've done that, then they'll ask, well, what was the outcome? And based upon the outcome, that may determine how the case proceeds.
Now keep in mind that, I'm sorry.
Just want to pause for a moment, because we have some folks tuning in, and we want to say hello and welcome Deborah, Franklin, Monica, Jason, Jose, and Jerry had a question. So I want to make sure, as he raised that, could I bring my claim to a state or city agency, that we cover that also in your responses.
You want to answer that, Royce? Or
yes, I mean, well, read that question one more time. Can you bring a case to a city or state agency?
Mm-hmm. Could you bring a claim? Could I bring my claim to a state or city agency?
Well, we have to define what city agency is, right? So,
if I may, the reason why I think both of us are kind of looking at the question a certain way is because what we would want folks to keep in mind is that many public employers have what they call their own EEO office, their own human
Right.
rights office.
Right.
And what you have to be careful is you have to understand that that internal office in that agency, it's not the same as the federal EEOC. It's not the same as the Division of Human Rights. In fact, I will pessimistically say, cynically say that really that's the employer's method of trying to keep you from suing them. They will have somebody there. It's usually a very nice person, personality out the wazoo, very nice, very kind, and very caring. They will say, "Oh my gosh, come sit down. What happened? What's wrong? Are you okay? Tell me what happened." And they will take down all of the facts. But the issue is whether they will or will not address your concerns. Now, some agencies' EEO office is robust. They immediately go after the bad actor, person of practice, and they say, "You know what? This is what we're going to do. Are you satisfied with that?" And the person may say, "You know what? That's okay." Because not everybody wants to sue. They just want the situation to be taken care of. You know, they don't want any issues on the job. They really like their job, whatever may be the case. But the reality of it is most of those offices are really there to try to keep you from suing. And so you have to be careful not to mistake that for an actual complaint to the EEOC or the Division of Human Rights. Because yes, you can file a complaint. And yes, judges like to see you say exhaust what they call your administrative remedies. I exhausted my administrative remedies. I filed a complaint because I told them that this guy was doing X, Y, and Z, or, you know, and you know, they didn't do anything. You know, judges like to hear that because they're going to say to the employee, "Hey, listen, what the hell did you do?" You know, and in many responses to these lawsuits, employers will, you know, raise that in terms of what they may have done or you know, what they did and so forth. So, and that becomes an issue in the case.
And I would add on to the balance of that question, if I'm understanding it. I understand it differently, but let me add so maybe we can.
Well, yeah, feel free to add.
No. Is you can clearly bring a claim in state court. It would clearly take a long time because state courts are backlogged. States do have policies against discrimination, so you can file for that in that arena. And discrimination, as I said, is broad. And you could also file for wrongful termination in that arena. Most wrongful termination cases are filed in federal court. And there's two reasons for that. One, you get a quicker adjudication. And two, the attorney, if they're filing for attorney fees, are more likely to get that in federal court. So, yes, there are agencies that you need to report to, a Division of Human Rights, the EEOC, that is outside of the company. Yes, you need to do exactly what Ed said, because the court is going to ask that. Did you exhaust your internal or administrative remedies? That means going to human resource. That means going to whatever EEO division that they have within the company and say, have them do an investigation and show the court that it went nowhere. And having done your due diligence outside of the company by reporting to one of these agencies. And on top of that, also show that you try to mitigate your circumstances during the time that this litigation is going on, or during the time that you're not employed. That's a whole lot for one person to carry in trying to be victorious in a wrongful termination claim where you only work for the company 3, 4, 5 years. That's not a lot of time. And so one other thing I would say is that you need to read your employee handbook, and you need to take it home with you, and you need to understand what's in it, because far too many times I will receive phone calls. Other attorneys will receive phone calls and say, "I was terminated. They only want to give me X amount of days of severance." And I say, "Well, what does it say in the handbook, in your employee handbook?" "I don't know." "Do you have a copy of the employee handbook?" "I think it's online somewhere." "No, I can get a copy from someone that's still working there." You have to plan your work your plan.
So this is a lot that we're covering for everybody that might be in a situation where you or a family member needs this kind of legal consultation, but I want to take it a step further because we're talking about this also in the context of COVID-19. There are new realities that are going on. You know, we opened up the discussion, we're talking about families, parents, single mothers, single fathers that were working remotely because of the COVID-19 pandemic, and they had children. Children are some back in school, some remote. And people are not all feeling safe, even with the vaccines out. Some folks might not want to go back into an office building. So they're trying to figure out, do they have any grounds to stand on and say, well, I've been working remotely from home during this whole crisis. Why do I have to go back to work? Do they have a ground to stand on? And how is this going to play out with litigation going on moving forward? Because this is a whole new world. Like, this wasn't an issue over a year ago. So COVID has changed the reality in this particular aspect as well of the law.
Well, what I would say to you is that decisions and case law has yet to be rendered in a way that we can really lean on. But let's go to the cultural part, and we're going to go back to the legal part too. The cultural part is that we have to understand the difference between privilege and what has to be. All right. I'm just good. And we put in quote, what has to be. There is a privilege for you to be able to work at home. It is a privilege for you to be able to watch your kid who is now at home, homeschooling or going virtual. It's not what has to be if your employer has presented, because that's the only obligation that an employer has to do, is present a safe work environment. That means sanitary, stations, right? That is masks. That is maybe creating cubicles. That is having a temperature, where you take your temperature when you come into the building. Having rotation. A team works 1 week. B team works another week, or they do it in colors. Green team goes in the first of the month. Blue team goes in the second of the month. Red team goes in the third of the month. Or you come in every other day, or you come in 2 days out of the week. Reasonable accommodations, safe workplace. That does not equate to employer having to satisfy your child care issues. And I don't say that lightly, and I don't say that unsympathetically, but I say it because it is the reality. All the empathy in the world, all the sympathy in the world will not be a business context reason for why a company is doing what they're doing. And we always see this in American disability type of cases, right? Where someone has a medical issue for which they have to be reasonably accommodated by the employer. And the word that we underline is reasonable. Not accommodated to the fullest, reasonable. So if everybody's back at work and we have those stations and there's cubicles, and when you walk in the door, you get a free mask and your temperature is taken, and you're not on the executive order by the governor or the state where you don't have to go to work, then you need to be at work.
Now, one of the things to keep in mind from what Dr. Grant said earlier was, you have some people who have, say, a person at home who may be immunocompromised, so forth. Keep in mind that most of the time that sort of issue is handled through the Family Medical Leave Act, because the Family Medical Leave Act is not just for your own illness, say, but or medical condition, but for that of a family member. And that is 12 weeks of leave. It can be periodic. It doesn't have to be consecutive. Okay. But keep in mind that once that's exhausted, or if you don't get the proper amount of medical documentation to provide to your employer, you're going to be out of luck there. You have
to keep in mind that sometimes the FMLA is a catch-22, right? It gives grounds, it gives room to go out with the old and in with the new at a lower rate.
Yeah, and it's not paid. It's unpaid too. If you exhausted your leave, because some people, once they exhaust their leave, they don't like FMLA anymore because you can be out, but you're not getting paid.
Exactly. And FMLA, the Family Medical Leave Act, has a beginning and an end. And so, to your point, Dr. Grant, it has a beginning and an end. And I don't want anybody to think that an employer has to, is obligated to ensure that someone's home with my kid while they are going to school virtually. It is not their obligation. Something they can consider, but it's not their obligation. And you can't call us up and say, hey, I want to file a lawsuit for wrongful termination because your employer said come back to work. You said I'm not going back to work because my kid is studying from home. What you have done is what Ed has said earlier is basically you have constructively terminated yourself. And some people would say insubordination, but I would say constructively terminate yourself. You created a situation, unfortunately, where you will now have to be fired. You then have very little rope to then go back to court and say, I was wrongfully terminated.
Well, one of the main reasons why I mentioned FMLA is thinking of a situation where my child came up positive for the COVID. The school is saying that they have to quarantine at home. I call my employer and say, listen, my kid, he has the COVID. He's home. I got to take care of him or her. Employer says, well, okay, do you have a letter or something or some sort of communication from the doctor just so that, I can have it for the record, because otherwise, and they have a right to ask for that because, you can't just call and say I'm staying home and just because they can make that inquiry and ask you to provide something. And that's why I mentioned, the FMLA. But, of course, that has its perils and pitfalls for sure.
Well, look, if it's genuine and it's authentic, then you need to use it. But once again, I will reiterate, it is a privilege / right that has a beginning and the end. The other stuff that culturally we may hide behind is not a right. It is a privilege. It's like a driver's license. You have the privilege to drive. It is not a right that you can drive. And that sometimes direct the conversation as to whether or not you need to go back to work. As you said, Dr. Grant, we're entering the time of COVID. If R Square ESQ PLLC says to his employees that I need to see that you have been vaccinated, is that unreasonable? Is that unreasonable? Because if it's not unreasonable, then it's reasonable. And if it's reasonable because you're going to be in contact with me and others, then what is your argument?
I'm glad you brought that up. I know you're going further with it, but I'm glad you brought that up. Is it really reasonable? Because there are many people who are not comfortable with this vaccination, even though they're saying,
look at the word that you use. The word that you use.
I know. I use the word comfortable on purpose, but there are quite a few people, particularly in our community, that's very cautious about it. I mean, we have a history of things going wrong and being tested in our community. So there's a whole narrative that's being played out. And that's the concern with them rolling out this vaccine across the country. So that's a real and present issue when we talk about where the legal meets the cultural, that culturally, some people feel that they can do what they need to do to keep themselves safe and not get vaccinated, just like people in this country have the option of not having their children vaccinated. So it's going to be an issue if a boss says you need to get a vaccination before you can come back to work.
To your point, Dr. Grant, when your kids don't get a vaccination, they don't have to go to a school. They don't have to go to B school. A B school says we want you vaccinated, and you say my kid is not doing, then you don't have to go to B school. I'm not saying that you have to work for R Square ESQ. You don't have to do that. Once again, it's a privilege. It's not a right. So if you don't want to do that, well, and we're talking about employment law in the context of suing someone, right? If you don't want to do that, you cannot come and sue me for wrongful termination. What you could do is say, Mr. Russell, I looked at the employee handbook, like, because I watched you on Facebook, I watched you on Speaking Legally, and the employee handbook, when I first started, says for every year that I work for you, you get 1 hour's worth of severance. I'm rude like that. You get 1 hour's worth of severance. And I work with you for less than 6 months, so I get point whatever of that salary. I'm being facetious. I'm laying a little light to the matter. But once again, right, privilege. You don't have a right to work for me. I don't have a right to hire you.
Now, if I may, with respect to the requirement that you be vaccinated, and keep in mind, folks, that this COVID thing is brand new. There have been arguments back and forth in terms of practitioners as to what the exact law is in this area. So just keep that in mind. My understanding is that one of the things to keep in mind is that the employer, in terms of a best practices, has to make sure that if they're going to make it a requirement that you be vaccinated, that it be uniform across all employees. They can't go to certain employees and say this. They have to do this widespread.
Exactly.
They also should set up what I believe is called a qualification standard, making it clear that, hey, listen, this is what this is what we're doing here. This is what this is what is the setup. Okay. And what I mean by that is that, once again, you can't have employers saying, hey, Bill, are you vaccinated? Well, I know Janine, I'm not worried about her. I'm worried about you. That is, now you're getting into this area of discrimination, because
we're getting in the area of disparate treatment and discrimination. But if everything is on board, everything is up, and for the light to see and very transparent. If the rule is, in order to come in, you need a vaccination, then you need to follow that rule. And now remember, we are talking in the broad sense, right? There's a difference between a state employee and a private employee. A private employer. A private employer who, whether it's family owned or whether it's a big conglomerate, has a variety of leeway that's different than the state. But if you have uniformity and there's reasonable accommodations to make that happen. So let's just say I ask you to get the vaccine, or I ask you to wear a mask, and you say, hey, there's no place in my area where I can get a vaccine. There's no place where I can get a mask. Well, as the employer, I might want to endeavor and to help you do that. You need to sign up over here. We found out that it's less, or X Pfizer or RCA or Comcast or whoever, whatever the company is, R Square ESQ. We have a direct line to St. Barnabas, and you go through our website. There's a variety of ways, and there may be a variety of reasons why you don't do that. But you realize that it's not a right.
Well, the other thing is in terms of the culture, where the legal meets the cultural. Now, you may have situations where an employee may belong to a particular religion.
Well, that's something different.
And may say that, look, listen, based on my religion, I'm not allowed to ingest that, fluid into my body. We don't vaccinate. Okay. And that employee can require you to get, some documentation to substantiate that from ecclesiastical member of clergy, whoever it is that is a recognized figure in your religious practice that can provide that information to the employer. And if I may, let me finish.
Wait.
Well, let me finish. The reasonable accommodation can't create an undue hardship for the employer, because that employer may say, listen, that's fine and all, but here I need you to do X, Y, Z, and that accommodation is going to be an undue hardship for me, and I have business reasons for having you physically here, so I'm sorry, you may not be able to continue to work here.
The point I wanted to make, and it's not in contradiction of your point. I support what you're stating. The point I want to make is that I hear your voice and I hear what you're saying. And I'm thinking about people I know that's sitting and might be watching this, who watch it later on. And the first thing they're thinking of, oh, I can go to my pastor. I can go to so and so. He
Yeah,
can write
yeah.
a
You
letter
have to do better
saying
than that.
No, that is not the case, bro. It doesn't work like that. And I don't want anybody to leave here thinking that, oh, I can just go to my church and they can write whatever it may be. They can write something up to saying, oh, we don't believe in that. Let me tell you, the employer is going to test that to the sky, because if the law and if you prevail in that area, then guess what? That's multitude. That's opening up the floodgates for people to fall in line, for companies to fall in line and acquiesce to what has now been established. And that's why I'm saying the law is unfair in this area, because it is skewed towards corporations and making sure that it, being corporations, don't have to follow something that we will regret in the future. And so it will not be that easy. It will be very, very burdensome to show that.
Well, this is a new reality that we're facing with this particular instance. Jason has been very active in the chat talking about his thoughts on the vaccination, and we appreciate everybody sharing their ideas. Where the legal meets the cultural is that these are some real-time situations that are going to unfold, because this is new territory when it comes to COVID-19, and the fact that the rollout of the vaccination is new and they're still trying to figure things out. So there's a lot to consider, but what can the community do as we start to close out this conversation, which we could definitely be here for the rest of the day talking about? What advice would you give everyone in regards to how they just advocate and protect themselves and their jobs?
Well, I would tell you one, the best way that you can advocate for yourself is to know, if not more, know as much as your employer. That means you should have read your handbook. You should know what it says in there, reference to Family Medical Leave Act, what it says about sick days, sick time. No one has in their handbook anything that has COVID related issues, because they just didn't think of it. But to have a basis of where you stand is important to elevate the conversation as to what you may need, and come to the table with the understanding that it is not a right, and you are an at-will employee if you live in New York and some of the tri-state area, and work with your employer to see, make sure you don't cross that line, as Ed said, that it becomes a burden for the employer, a hardship for the employer to have you employed there. As Rodney King said, can we all get along here? That's the motto that we have to take into the room as soon as we walk in the room. Ed?
Yeah, no, absolutely. The mindset here is definitely a consideration of all interests, both that of the employee and the employer. What you have to keep in mind is that as an employer, you have an obligation to the employees that are under you. So, if you have somebody saying that they want to work at that workplace without either being vaccinated, don't want to wear a mask, but still want to be there, that employer can say, hey, listen, wait up. I'm also responsible to your fellow employees to make sure that they are protected as well. So that's what we have to keep in mind here. And also, for sure, the telework idea, the distance working from home, some people are saying that, yeah, that's possibly going to be a trend for the future. But if your employer isn't embracing that trend, and based on the needs of their business, they actually need you there, and they say to you, well, that's it. I hired a company to wipe the place down. I set up the barriers. Your particular area, I did this, and that. I put in a set of practices, read your latest handbook, because many employers, they've come out with 2.0, 3.0 handbooks dated December 2020 or January 2021. Best believe the larger employers have, with these are the new protocols of the day, You can't just come up with, well, I'm not comfortable, or I don't, I don't just feel good coming in like that, or I don't believe you. It's gonna, at some point you're gonna have to say, hey, listen, I guess it's gonna be that time to go in, or in the case of having to be vaccinated, if you can't show that there is a medical reason for being excluded from that vaccination rule, then you're going to have some serious issues in terms of either being able to keep that job or staying there. It's not going to be good enough to say, well, I don't know what the problem is. We've been doing just fine working from home. I'm getting my work done. I don't know why they want us to come in. This is BS. That's not going to be good enough. You got to be able, if you're going to sit down with one of us, we're going to ask you a lot of questions. We're going to ask.
It's not going to be good enough to cite.
We're going to ask you for the exact facts. How many employees work there? Because we also want to see if the employer is mandated to follow the ADA. You have to be a certain size too. Well, what does your workplace look like? How many employees? What exactly do you do? Is there a business necessity behind you having to be physically there? All those things. What is the employer saying? What exactly did they say? Was it voluntary or not? That's sort of, we're going to ask you a lot of questions. You got to be prepared to sit down and answer them and not get impatient and say, man, come on, man. Bottom line is, that stuff is poison, and I'm not putting it in my veins, and I don't need to go back, and you're not helping me out. You just asking me a bunch of questions. Do you even do this stuff? You're never
going to escape the ungrateful comments of being a servant of the law, LAW, and you definitely ain't going to escape the unflattering comments being the servant of the Lord, LORD, right? So you're going to get it one way or the other. But what I will tell you is that citing African American history and all the experiments throughout life is not going to get you to the front of the line, right? That's number one. And number two, check this out. You may have to be flexible. So after the employer says, you know what, Mr. Pichardo, I see your point. You don't want to get the vaccine. I understand. And you coming in 9 to 5, I understand. I have to protect my other employees as well. So what we're going to do is you come in at 6 o'clock and you work 6 to 1. You come in at night now.
Man, I can't be doing that. Come
on. Exactly. You get the drift? The
subways is dangerous. You see the people on the subway at that hour?
Exactly. You come in at 4 o'clock. You work the 4 to 1 in the morning. And what we're going to do, we're going to remove your duties that you used to have, and you're going to keep your same pay, but you're going to have these other duties.
So I think we've had a very robust dialogue today. Jason has made some other points about making sure that they sign a waiver that the vaccination won't give you any side effects. That's a whole nother show, bro. And then he's like, it's also time to get into business for yourself. And that is the point. Like, if you are the boss, you have your employee handbook and you can do what you desire when you're signing your own check. But for those who can't.
But Dr. Grant, what was funny with that is that if you are the boss, guess what? Somebody's working underneath you and working with you. And so now you're setting up the rules. And so now you ain't cracking the jokes that you cracking. Now you like, yo, wait a minute, hold up. What did Mr. Russell say on page 6? This is not all right. It's
no. And listen, what happens when the other employees come in and they say, yo, my man was walking around yesterday with no mask, coughing. What you gonna do about that, man?
And to Jason's point, here's the corporate politics. When the shoe fits and you walking in it, you be surprised what you say and do, because you and I both know. You and I-T-Y, or you say you and I-T-Y, you know what the deal is.
And with that, ladies and gentlemen, this is another episode of Speaking Legally, where the legal meets the culture with your two legal experts, Royce Russell Esquire and Edward Pichardo Esquire. This has been a great show. More to talk about. more to do, but make sure you read something before you need something. And Mr. Russell always says, get your copy.
That's different.
We're going to have to do an expanded version where both of you are talking about employment law. But that's it for today. Make sure you tune in next week, same time, 4 p.m. Eastern Standard Time. Find us here on all social media, on the YouTube channel, and we look forward to being with you again. Bye for now, everyone.
Take care. Be well.